Hi, I'm Akash Kashyap, and today we're going to be talking about another form of contract in the entertainment industry, the inter-artist agreement. Now, in many creative fields, it's either unusual or impractical to go it alone, so to speak. You need the help of others. So whether it's part of a performance group, a band, or some other type of collective, you will be going at your career with a group of other creatives. However, when your works, your obligations, and your professional careers are so intertwined, there is always a high chance of conflict, and for that conflict to turn destructive. In order to avoid destructive outcomes, such groups will engage in inter-artist agreements. These are agreements that are going to allocate the roles and responsibilities of the members, that are going to describe how rights and profits are allocated, and handle what happens in the event of termination, whether one member leaves or if the group as a whole is dissolved. So let's take a look at how these agreements are structured, and first talk about the roles and responsibilities that are allocated within an inter-artist agreement.
In an inter-artist agreement, the responsibilities refer essentially to the allocation of duties between the members of the performance group, band, or other collective of creatives. Now, these responsibilities can generally fall under 4 headings. The first, the most central to their presence in that group, is the creative, and this can include obligations to perform and obligations to record. The second heading is promotional. This is their obligations to participate in the selling and the promotion of the collective's work. This can include press obligations, this can include restrictions on their use of social media, and general non-disparagement clauses, restrictions on their ability to badmouth or negatively impact the sale of that group's work. Third heading is tours. This is where they go to perform, exhibit, or share their work across various geographic regions. And this will allocate their requirement to be available for such tours, the notice that is due to each member for such tours, and their right or any prohibitions on their ability to take breaks. Finally, there's a restriction on the behavior of the members. This includes restrictions on them engaging in conduct that will result in a negative image or a negative impact on the group, which can include legal issues, overall image management to fit the collective's brand, and occasionally sobriety requirements to ensure that the artists are able to function and contribute in their right state of mind.
So now that we've got a bit of an idea as to how roles and responsibilities can be laid out in an inter-artist agreement, let's talk about the flip side of that, the allocations. What each member is going to get out of it, whether that's in the form of credit, in the form of ownership, or in the form of profits.
So allocations in an inter-artist agreement refer essentially to how the various assets and incomes of that group or collective are to be split amongst the members or the parties of the inter-artist agreement. Now, there are 3 things essentially that are to be divvied up. The first is credit. Essentially, how is everyone credited? What title are they credited in? And in what order are they credited? Second, ownership. Who actually owns the copyright on the works? Who owns the copyright on any of the brands? This can be brands such as lines of works or the overall brand, the name, logo, and other creative aspects that signify the collective as a whole. And third, and potentially most importantly, is the allocation of profits. Now, this is an incredibly specific aspect that is often drafted very carefully, and it describes how profits are to be calculated, what profit will be allocated to what work if profits are to be divided by work, and how they deal with additional profits, such as merchandising profits, name rights, advertisements, touring profits, etc.
Now, when it comes to the day-to-day operation of the group, this is sufficient. The roles and responsibilities tell each member what they have to contribute, and the allocations tell what each member gets in return. However, the agreement also has a responsibility to handle what happens in the event of termination, whether it's one member leaving the group or the group as a whole dissolving. Let's take a look at how the agreements can handle this.
When it comes to the termination of an individual, there are some key aspects that need to be looked into. First, how much notice must any individual give before terminating their relationship to the collective? And when they have terminated, what outstanding obligations do they have, both with regards to the promotion of work that they participated in the creation of and the performance of work, both the performance of creative works that are still in progress and need their presence to complete, and live performances or exhibitions that they are already obligated to show up for. You also need to look at the rights they have over the various works produced by the group. Now, this includes their rights over works that are completed and released, works that are completed but not yet released, and works that are incomplete but that they have contributed to. Now, when it comes to the termination of the group as a whole, there are similar calculations that have to go in, but with the understanding that there's much more of the band to divide up. Now, again, you do have to deal with how the rights over works are to be divvied up. Those that are completed and released, those that are yet to be released but complete and ready for release, and those that are incomplete and likely won't be completed. Who owns the various contributions to that work, and how is it to be allocated out? Beyond this, though, you also have to deal with the allocation of the brands and other overall assets of the group. If, for example, your band is breaking up, who owns the right to use the band's name? Who owns the right to use their logo? Who owns the right to sell merchandise that relates to the brand? Similarly, there is to be a final tallying up of profits and losses, and whichever way the accounting goes, black or red, that also needs to be allocated amongst the members, and the inter-artist agreement has to provide for how it is to be calculated and how it is to be allocated.
So inter-artist agreements handle a large part of how members in a creative group are going to be handling one another, what their individual roles and responsibilities are, what each of them will be allocated, whether in the form of costs, ownership, or benefits, and how the band will operate if one person leaves or if the group as a whole dissolves. It's very important when you're undertaking a creative work with others to enter into an inter-artist agreement. While it may not seem like conflict could ever be on the horizon, if you look at the statistics, conflict is inevitable. And to make it go as smoothly and as clearly as possible, ensure that you have an inter-artist agreement in place. We, again, would advise you to consult an entertainment attorney in order to discuss the formation and to create your own inter-artist agreement. Hi, I'm Akash Kashyap, and today we're going to talk about another agreement common to the entertainment industry, the work for hire agreement. Now, oftentimes when you're creating your work, you're not going to be able to do every aspect of it yourself. And this is especially true in more involved productions like audiovisual mediums or music or performances or so on and so forth. Now, in these cases, oftentimes the direction or the creation or the main artist is going to be one or a handful of individuals out of all those contributing to the work. However, given the way that copyright works and how it can automatically attach to creative works, it can be troublesome to include those individuals in the production that aren't intended to be owners of the work itself. In order to allow contributions from employees, contractors, and subordinates that aren't supposed to own the copyright, you have to engage in a very specific type of agreement, the work for hire agreement. So today we're going to look at what a work-for-hire agreement is, how it's formed, and key features of the agreement.
A work-for-hire agreement is a statutory tool by which the first author of a copywritten work is determined and is often separate from the individual actually making the creative development, performance, or work that is involved. Now, unlike the assignment of ownership of a copyright, which can be done through an ordinary contractual relationship, this is something that occurs only through statute. Now, this relates generally to the additional rights, such as reversion or droit moral, that apply to the first author. And in order to have those assigned properly, you need to have a proper, statutorily compliant work-for-hire agreement. In essence, the work-for-hire agreement takes advantage of a small and incredibly narrow exception to the standard conception of copyright, which is the traditional way in which copyright is developed and is treated by law.
Now that we've got a basic idea of what a work-for-hire agreement is and how it's formed, let's look at some key features of the work-for-hire agreement, what it can do, what it can't do, and what makes a work-for-hire agreement different from any other form of agreement.
As a statutory concept, there are some key requirements, key elements that make a work-for-hire contract valid. So let's go through these in order. First, the agreement that designates a work as a work-for-hire must be made prior to the creation of the work. The contributor has to sign the agreement that designates the work as a work-for-hire before they contribute to the work. It's not something that can be done retroactively. Similarly, the creation of the work has to be in accordance with the contract. For example, if you hire someone to play backing vocals on your song, if they then start contributing as a drummer, as a arranger, start providing fronting vocals, or perform any other instrument, they are not contributing in accordance with the contract. And those creative elements that are added outside the realm of the agreement that was created will not be covered by the work-for-hire contract. Now, the combination of these two requirements for a valid work-for-hire agreement does make it important to have in place both evidentiary and legal stopgaps within the agreement to try to claw back ownership over any work that exceeds the agreement or that was created or developed prior to the agreement. Now, when it comes to the evidentiary stopgap, first, there needs to be the employee's acknowledgement. This acknowledgement will have to acknowledge that nothing that they contribute was created prior to the creation of the agreement, that they are only going to operate within the bounds of the agreement, and anything that they contribute should be construed in such a manner, and that they are willingly giving up their rights over the work by creating it as a work for hire. On the legal stopgap side, you need to have both an employee waiver, whereby they waive any rights over the work that they're contributing, whether or not it's a work for hire, and as a final failsafe, there needs to be an employee assignment, where if there is any element that they contribute which cannot validly fall within the ambit of the work for hire, you still don't want them to be able to claim ownership and to be put in the position of having to buy the rights off of them for their contribution or scrap the song. So the final legal stopgap is an assignment agreement, whereby anything that falls outside the bounds of the work for hire, anything that cannot be demonstrated by the evidentiary stopgap and doesn't fall within the ambit of the waiver, they will, for no consideration, transfer over to you as part and parcel of this agreement. Now, these two stopgaps are not 100% effective, which is why it is essential to make sure that your work for hire agreement is drafted carefully and that the production and the contribution of the contractor occurs within the bounds of that agreement.
So as you can see, the work-for-hire agreement is an essential agreement that helps delineate the difference between those that are working for you while you are producing your work and those that are collaborating with you on your work. This is a very specific agreement that has some key statutory requirements without which the agreement will fail, and your collaborators may include those intended to be contractors. In order to make sure that your agreement fits all of the statutory requirements of a work-for-hire agreement and that your contractors don't become inadvertent collaborators or owners of the copyright to your work, consult an intellectual property or entertainment attorney. Hi, my name is Akash, and today we're going to be talking about talent agreements and what you should keep in mind before signing on the dotted line. Now, talent agreements, they're a very common part of the entertainment industry. Whenever you're going to enter into a collaborative production, be it a movie, television show, the production of an album, a concert, a music video, an art installation, or any other similar production, you are going to be entering into a talent agreement. And that's going to govern the basis on which you provide your creative services to the project as a whole. But when you're entering into one of these projects, there are three things to keep in mind. The 3 C's: compensation, credit, and the contingencies. Let's first take a look at compensation, the means by which you're actually going to be paid for your contribution to the production.
Now, compensation can seem like a simple issue of, how much you're being paid for a certain amount of work, but it's slightly more complicated than that, especially in the realm of talent contracts. What you have to know is that there are a couple of different ways of calculating the compensation. It can be as simple as a flat fee for an entire project. It can be a flat fee for a certain unit of time, be it a per hour flat fee, per day flat fee, per month flat fee, and so on. It can be a certain performance-based percentage, whether that's performance in an internal sense, performance in terms of the outflow that you have, or performance of the project as a whole. So this is something that goes into calculating what essentially your compensation will be. And since it's variable this way because of the fluid nature of production, where you can run over budget, you can run over time, you can end up finishing quickly, there may also be a provision for a minimum and a maximum total fee. So that's another thing that you want to pay attention for, especially relating how that comes into contact with the way that your fee is calculated. You want to make sure that you don't have a large per hour fee, but then a small cap, because that would effectively be functioning as a flat fee overall. So these are things that you want to take into account when you're looking at compensation. Another big issue that's related to compensation is the issue of expenses. Now, for a lot of creative works, you're going to end up undertaking certain expenses, whether it's travel, accommodations, just, food and drink, any other associated consumables that are involved in your creative process could be considered expenses. And that's something that is going to offset the income that you get through your compensation. And so figuring out the allocation of these expenses is going to be crucial to understanding what your actual end of the day compensation is going to be. For example, if you're getting a certain fee per hour while working on location, but you're responsible for taking care of your own accommodation and your own meals, you could very quickly find out that you're actually coming out of this behind, where you're spending more to do work on the project than you're taking home as your salary. So these are things that you all go into figuring out exactly what you are being compensated with during the production.
Credit refers to the obligation of the producer to ascribe to you credit for the work that you contributed to the project as a whole. And it is essential when you're going to promote your career and get further work.
Now, when it comes to credit, there are 3 issues that you're going to want to look into. The first is title. Under what title are you being credited? The second is the position and prominence of your credit. And the third is what happens to your credit in case you are terminated or the project is terminated. Now, first, when it comes to title, that is important in establishing what role you will be credited in within the project. And that credit, that title, is essentially what you'll be able to show within your body of work. Now, let's say that you contribute some music to a film. That can be credited, depending on your contract, either as a composer, either as a contributor of sounds, or you can be credited for the individual work alone. And depending on how you're credited, that is how the credit will appear within your body of work. And so when you go on to your next work, you'll be able to say either that you were a composer, or that you contributed sounds, or that you composed a song that was then credited as such within the work. Similarly, the position and prominence of your credit within the body of work is also essential. If you're headlining, that's where your name comes up at the top. It could be that within the credits, there is a division, such as in a film, for those above the fold, where they get extra prominence and are displayed prior to the title crawl, or below the fold, which is people that come after the title crawl. And this positioning and prominence, that is how related you are to the final work in terms of the marketing that you have, in terms of how you can get your name out there, so to speak.
Now, the compensation and the credit are essential for understanding what you're going to get out of the agreement, whether it's going to be a good, positive step forward in your career, and whether it's going to provide you with remuneration worth your time and your efforts. But beyond this, you should also look at what the contract does in cases of contingencies, what the obligations of the parties are when things go wrong, and how best you can salvage your effort and time should the project not go ahead as planned.
Finally, you have to look into the contingencies associated with the project. Essentially, if something goes wrong with the project, what is going to happen? One, what is going to happen to the costs that were incurred? What is going to happen with regards to the work that was done but not compensated? And oftentimes, what was going to happen to the work that you contributed? Now, some have a savings clause which allows you to reuse or take ownership of any contributed work that wasn't used in an aborted project. So in order to make sure that if the project fails, you're not left holding the bag, you do need to look into what is going to happen in the contingency case.
The 3 C's: compensation, credit, and contingencies. You should have a good idea of how to go through an agreement and understand at a basic level whether it is an appropriate and safe deal for you to undertake. That being said, it's always good to seek the services of a trained entertainment lawyer in order to understand any poison pills or the exact ramifications of the agreement that you're about to enter. Hi, my name is Akash, and today we're going to be talking about agency contracts and what you should know before signing on the dotted line. Now, agents are an essential part of the entertainment industry. They're the ones that focus on making sure that your best interests are represented in any deal that you undertake or any production that you join on for. And they are the ones that are promoting your career and making sure you have work opportunities while you focus on creating your art. However, when you're engaging an agent, it's important to analyze the agreement from 2 aspects. First, the commission, which is how they're getting paid, and second, the services that they will provide with you. Let's start by taking a look at the commission and some key factors to look at. Now, the commission can be calculated in 2 ways: as a percentage of your income or as a flat fee for services rendered. Now, the most common method is through a percentage, but here you have to pay attention to a few things. Whether the percentage is being cut pre or post-tax, because you have to understand that given the amount of tax you will be liable for, the percentage can result in a wildly different real amount of payment when it's calculated pre or post-tax. So you could end up with a much smaller percentage being applied pre-tax, resulting in a much greater liability than a larger post-tax percentage. You also have to pay attention to qualifying income. Now, what this means is the income that is subject to the commission. Now, this can be in any number of ways. It can be either a overall percentage of income. Any income that you get is going to be subject to the commission. It can be a industry-based percentage. Any income within the specific industry of the representation is covered. For example, a musical artist will be subject to a percentage for all of their music-based income, but if they take up sculpture, that will be exempt. It can also be limited to the actions of the agent, which is to say they only get a percentage of those deals that they actively create. Now, depending on what the qualifying income is and whether it's calculated pre or post-tax, an appropriate tax level can vary wildly. It can range from single digits to, in percentages in the 20s or 30s. Now, as for flat fee arrangements, these are fairly uncommon in the industry, and they come in two categories. The first is periodic, where representation over a certain period of time will be subject to a lump sum flat fee, let's say a monthly fee or a quarterly fee. And others are service-based fees, which is to say certain services that are provided will be subject to a itemized bill, which is to say if you are negotiating a deal, then the amount of time spent negotiating will be a flat fee service. If you are being promoted, that promotional activity will be subject to a flat fee, and so on. Now that we've discussed the commission and how your agent is going to be paid, let's turn to look at the services that they're going to provide you and how that changes what an acceptable commission would be. The services that your agent provides can come in a number of different forms, and it is very important when going through the contract to understand essentially what you're paying for. Now, when it comes to representation, one thing that you have to keep in mind, are they talking about passive representation or active representation? Active representation refers to them going out and getting you work, getting you contracts, getting you opportunities to promote your career, whereas passive representation refers to simply looking over deals as they come through, putting your name onto certain forums, and generally waiting for a deal to come before intervening. Now, as you can guess, one is much more valuable than the other. Similarly, you have to look into what industries your agent is going to represent and what industries they're not going to represent. Now, it may be common sense that if you are an actor and a singer, you're going to have agents that are experienced in the music world and agents that are experienced in the acting world. And so you would have two agents. But even in a field that seems as homogeneous as literature, you can end up with different agents for different genres. So if you're someone that writes horror and occasionally literary fiction, it isn't uncommon to have a literary agent as well as a horror agent. If you write adult fiction but occasionally dabble in young adult fiction, those will often require separate agents as well. If you have multiple publishers with different series or different bodies of work, you could often end up with different agents. So you need to understand the limitations on your agent's representation. There are other limitations that can apply as well. There are geographic limitations. Are they going to operate for all of your works everywhere? Are they only going to work in the Western market, only going to work in the American market, only going to work in the greater New York area? These are different types of representation that will result in different types of appropriate compensation. One more thing to consider are additional services. These are services that aren't covered by the commission that your agent may be undertaking or that may be routine to your industry, but that would result in additional fees and charges. That's another thing to keep in mind when going through these contracts. See, when you're entering into an agency relationship, there are two things to keep in mind. The commission, how much you're going to be paying and in what way that's going to be calculated, and the services that they provide, what is included in their representation and what is not. Going in, understanding what you're getting and how much you'll be paying for it is the key basis for this transaction.
Thank you for watching. If you like this video, please feel free to give us a like, give us a comment with any thoughts that you have on the subject matter, and subscribe to see more content coming soon. Thanks.